All right, everyone. Peace, peace, peace. How's everybody doing? Let's see what we got. What's going on? What's going on? Comments starting to come in. Peace, peace, peace. How's everybody doing? We're going to get to it today. First and foremost, I want to make everybody aware that I have a webinar this weekend. All right, it's going to be this weekend. And let me pull it up for you. This weekend. And all you have to do if you want to attend is to go over to SPC University. That's our website right there. Hit the shop page right there. And you can register right here. Securitization, isolation, and set off of obligations. Securitization, isolation, and set off of obligations. I thought that was an appropriate name. Or when you try to discharge debt, a lot of that has to do with it. But that's it right there. And you can hit the link at spcuniversity.com and you can register for that webinar. Okay, today I'm going to continue. This is the inside of SPC University. Here is our academy, and we'll go to our download materials. And down here at the bottom is the document I was reading yesterday, Realities of Private Ordering. And when we get back into the realities of private ordering, because I really think this is a very important thing for people to understand, because what I saw, let me put back on the screen. When I came in, when I was very first introduced to this information, I was also introduced to the concept of public and private. And I just noticed that that's just what a lot of people, they just aren't aware of the distinction. They keep seeing the words. So they see the words public everywhere and they see the word private everywhere, but they don't understand the distinction between the two, or um, how to conduct their affairs in each domain. They think the domains are a label. So they'll call themselves private. Well, I'm private. No, you're not. You don't call yourself private. You have to conduct yourself privately. And in conducting yourself privately, that's a particular way you have to do it. You just can't be arbitrary and capricious with it. You have to know what you're doing in order to establish some sort of private identity. That is a skill that you have to acquire. That's not a label that you get by declaration. So that's the biggest issue I see with this community is everybody puts labels on things, and they think by switching the label off and changing it to another label, then something has fundamentally changed about the situation. And that's not how law works at all. And that goes against common sense as well. That's not even, common sense doesn't even agree with that. All right, so let's get back to our document. So this document here, let's see. All right, this document right here. All right, yesterday we were going through, and I'm going to start back on legitimacy is not jurisdiction. No, we went past that. Let's go down here. How these arguments actually fall. We did that. Yeah, let's start right here with what private ordering actually delivers. Okay, this part is the point of the handout. Everything about it is preparation for it. The domain of genuine private ordering is very large, and most students who reach for the failed arguments have never been shown its actual contents. And that is actually true. Nobody has really in this space have been actually really been shown what is the private domain. They just been winging it and kind of going based off of their own limited understanding of what they think privacy is. But that's going to change today. We're going to give you a definite, you're going to know definitely after today. So, what's the real inventory? The instrument, contract, what it genuinely accomplishes. It sets terms, allocates risk, defines performances, fixes remedies, liquidates damages, allocates the cost of disputes. Vast majority of commercial law is default rules you may rewrite. Choice of law. Party choice is honored where the chosen state has a substantial relationship to the parties or transaction, subject to the fundamental policy limit. Restatement second of conflict of laws, subsection 187, real, powerful, and bounded. Choice of forum. Forum selection clauses are presumptively enforceable and controlling in all but the most exceptional cases. M.S. Brenman versus Zapata Offshore Company, Volume 407, U.S. Reporter, page 1, 10 through 15, publication year 1972. And also Atlantic Marine Construction Company versus U.S. District Court, Volume 571, U.S. Reporter, page 49, and also pages 62 through 64, publication date 2013. Selects the decision maker, the arbitration agreement, selects the decision maker, the procedure, the applicable rules, the confidentiality, and the finality. The strongest single instrument available are arbitration. Arbitration agreements are a part of private ordering. One of the strongest things in private ordering, where you select the forum, you have to do this beforehand. You can't do it after the fact. You got to arrange your affairs beforehand so then you can get the desired outcome. Nothing happens after the fact. Trust, separate legal from equitable title, governs succession without probate, specifies distribution standards, allocates fiduciary duty, provides for incapacity. And a lot of people don't put that in their trust indenture agreements. A lot of provisions for the incapacity of trustees and things of that nature. Spendthrift protection is narrower than students expect. A spendthrift clause protects a beneficiary's interest from the beneficiary's creditors and does nothing for a settler who is also a beneficiary, except in certain jurisdictions like Nevada and South Dakota. Self-settled spendthrift trusts are permissible within certain limits. Entity structure limits liability, allocates control separately from economic interests, defines transfer restrictions, provides deadlock resolution and exit mechanics, subject to being actually operated as an entity. So your entity structure, your LLC, your C Corp, your S Corp, these are your tools of trade that you use when you want to maintain privacy. You operate through artificial entities. Private association. Freedom of expression association is constitutionally protected. Roberts versus United States JCs, Volume 468, U.S. Reporter, page 609, as well as 617 through 623. Publication year 1984. And Boy Scouts of America versus Dale, Volume 530, U.S. Reporter, page 640, as well as pages 647 through 656. Publication year 2000. Real membership governance, internal discipline, and admission control, not an exemption from regulation of what members do. Okay, agency creates authority in another to act for you and to bind you. One of the most powerful private instruments in existence and one of the most frequently botched. Agency is a part of private ordering. You get somebody to do it for you, like you have a driver in your car, somebody who drives for you. Okay, that's why wealthy people have drivers. They're not running around talking about I don't need a driver's license. They have somebody to drive for them. Mediation expert determination, industry tribunals, internal grievance procedure, often faster, cheaper, confidential, and preservative of the relationship. So let's look at agency real quick, how authority is created and how it fails. Agency delivers its own section because it is simultaneously a major instrument of private ordering and the most common point of technical failure in the instruments this institution's students draft. Where authority comes from. Actual authority arises from the principle's manifestation to the agent as the agent reasonably understands them. Restatement third of agency, subsections 2.01 and 3.01. This is settled. Okay, settled means that, hey, there's no dispute about this. You can argue, you don't want to even argue with it. Everybody is in agreement on this point. Apparent authority arises from the principle's manifestation to the third party. Restatement third of agency, subsection 2.03, settled. And ratification adopts a prior unauthorized act and gives it effect as though authorized from the outset. Okay, and that's like, silence is acquiescence. You could give ratification to your agent's actions. The rule students most need. An agent cannot create his own apparent authority. Apparent authority is traceable to the principle's manifestation, not to the agent's assertions about himself. This is also where my book, The Verification Doctrine, you go to SBC University. I've written a book. It's called The Verification Doctrine. This is a very, very good book. This right here tells you how, if you want to trace somebody's delegation of authority, where does authority come from? Where does the documentary footprint lead to? Okay, every assertion of authority can be traced back to a delegation of authority. And this right here tells you the steps in doing that. If you're going to challenge jurisdiction or any of the things that you like to do, this is the type of book that you need. If you're going to challenge third-party debt collectors, it goes for everything, not just criminal law, not just civil law, just everything in law. I took a great amount of time to do. I think this book is about almost 100 pages, but it is for the serious student. It is not. It's not an easy read. I'm going to say it's going to require study when you study this. I wrote it intentionally like that. It's not a flimsy PDF ebook. It's an actual book that I'm going to publish. The rule students need most need. An agent cannot create his own apparent authority. Apparent authority is traceable to the principle's manifestation, not to the agent's assertions about himself. It follows that no self-description confers power. Signing authorized representative, attorney in fact, or trustee does not make it so, because you need to have documents to support what you're saying. Once again, this is another reason why you do the secure party process. There's reasons for that, because now you have an agreement in place. Now you've given notices in place before you do anything. Once again, make sure that you are at the webinar this weekend. Okay, it's going to be on Saturday from 11 a.m. to 3 p.m. and on Sunday from 1 p.m. to 4 p.m. Okay, I see a lot of y'all are signing up for it too. Okay. So let me read that again. It follows that no self-description confers power. Signing authorized representative, attorney in fact, or trustee does not make it so. The signature block is a claim. The source of authority is a fact. Okay, so when you sign your name in a particular way, that's a claim. Okay, but you have to be able to establish that. It has to be verified. So the source of authority is a fact and is found in a governing instrument, a statute, or a course of conduct by the principal. Capacity is conferred, not claimed. This is pattern 4 in its most concentrated form. Once again, I remember I read a book where this military guy, let me see if I can find it, man. Go to my Dropbox. I want to see if I can find this. I'm going to see if I can find this real quick. Because what this general said, he said that the civilians don't understand that their rights are enforced through contracts. And I understand that so much now. Let me see if I can find this document, man. Document was good. It was I'm looking for it, y'all. Let me see if I can. I want to show it to you because that general, when he was explaining that, I was like, man, that's it right there. He was explaining that civilians don't understand their rights are enforceable through contract. Like a lot of people say, well, I have private rights. Okay, well, rights have corresponding duties, and also rights have to be enforced. And how you don't have any rights if they can't be enforced. You don't have any rights if they can't be enforced. Okay, who's going to enforce them? So that's the first thing. Let me see if this is it right here. No, that's not it. I might have to come back to it. I was trying to see if I could find it in my Dropbox. I'm gonna find it though, because I want to show it to all of you because it was really interesting. That general was talking, and he was saying that he said the civilians do not understand that their rights are enforced through contracts. And I understand that now because you have to have something in writing when you're going to go to court. You can't just say, and then it has to be a verifiable source. You just can't make up your own authority. You're just claiming that you got this authority. Okay, where did your authority derive from? You got to be able to explain that, and your authority cannot infringe on their. Oh, here it is, right here. The Army lawyer. I found it. I found it. Hold on. Let me put this. I'm gonna put this on the screen. I just found it. I just found it. Uh, let me put it in Chat GPT real quick. On what page? Y'all give me a second. I'm gonna get it right now. Let me see. Well, guys, let me put this on the screen real quick. I think this is it. Let me see. My chat is I've read it so long ago. Okay, page 3. All right, let me put it on the screen for y'all. All right. All right, so right here, Chad, I uploaded this document. The Army lawyer said the passage you are remembering begins on page 3. The Army lawyer in the article Thinking About Due Process by Major Richard D. Rosen. It was a major, not a general, who made the statement. Okay, it's my fault. It was a major. The key language: property interests and some liberty interests do not spring from the Constitution or some natural law. Instead, they are established and defined by non constitutional sources such as statutes, regulations, and contracts. The stronger statement is on page 5. Rosa makes the proposition even more explicit. Property and some liberty interests originate in state law or contract. They are not freestanding human rights. Then on page 7, he develops the contract point further. He says the Supreme Court looks to state, federal law, or explicit understandings between the state and the individual. That's right there as a contract. And ask what statutory, regulatory, or contractual language is sufficient to create a protected property interest. He specifically discussed implied contracts and mutually explicit understanding as a source of an enforceable entitlement. And here is the civilian specific discussion. On page 9, Rosen specifically discusses civilians. He explains that where no law or regulation restricts a commander's discretion to bar civilians from an installation, there's ordinarily no protected interest requiring process. But if the government establishes rules limiting that discretion, the rules can create a property or liberty interest, which then carries notice, hearings, and judicial review protections. So for your presentation, I would mark pages 3, 5, 7, and 9, with pages 3 as the passage you were probably remembering. One important qualification: Rosen is not saying that all civilian constitutional rights exist only through contracts. In fact, on page 9, he expressly says that most liberty interests flow directly from the Constitution itself, with certain government created property interests, and some liberty interests arise from positive law, regulation, or contractual relationships. That distinction is extremely important to the public right, and public private ordering discussion you've been developing. So, if here's the document right here, the Army Lawyer, called the Army Lawyer, and headquarters Department of Army, right here. This is 1988. Thinking about due process. Right here, Major Richard D. Rosen. That's him right here, thinking about due process. I had this and I was just reading it, and all of that information was in there. And that's what it is. What people need to understand is that for you to have an enforceable right, it has to spring from somewhere, like, the Constitution, obviously, but in particular, it needs to be in some sort of contractual type form. Um, if you're going to take it in court and look for some sort of enforceable right in some sort of property interest or something like that. Uh, for a matter that goes also with the 10 maxims of commercial law. For a matter to be uh, for a matter to be resolved, it must be expressed. And the spoken word flies out the window and the written word remains forever. You want it in writing. So that naturally goes to in private ordering that everything is operated through a contract. Because what in the Constitution it protects your right to contract unlimited. Okay, they can make no law that will infringe on the obligation of contracts. The only thing you have to do is draw up your contracts in a way where they do not infringe upon any type of public policy. You can't write a contract to do just anything or violate a public right. Can't do that. I'm doing okay. Thank God, coin for 10 jewels. Conspicuous is a great word. Turn up the volume, please. Volume is turned up. What you talking about? Let me turn up the volume. Well, y'all can't hear? Yes, yes, yes. Yeah. Okay, I gotta go over here. All right. All right, what we got? And honor yourself from Huntsville, Alabama. Okay. Let me see. Are y'all following what I'm talking about? Let me make sure I'm not losing y'all in the chat and everything. Is everybody give me a thumbs up if you're understanding what I'm talking about? To what extent can private ordering substitute for public law in complex? Private ordering does not substitute for private law. I mean, public law. You need to watch how you write things. Like you see that right there shows me your understanding of something. Private ordering is not a substitute for public law. It's not a substitute. It operates within the framework of public law. So just how you frame that right there shows me you don't understand the subject right now, because just how you frame the question, you're trying to make it into be something else that it's not. You know, Matter of fact, let me put this in chat and see what chat says that. What extent private order is substitute for multi-party environments where power asymmetries exist? That's a strong question because it identifies the boundary. Let me put it in the chat for you. Damn, this shit is long. Let me post it. I'm gonna post it over here. Becomes functionally, I mean, what did he say? He said, to what extent can private ordering substitute for public law in complex multi-party environments where power symmetries exist? And how do we measure when private governance becomes functionally indistinguishable from state regulation? Okay, yesterday, let me answer the question for you. Yesterday we had an example of some ranchers that were up north who do what's called reputational based systems, which is a part of private ordering, where they were not even aware of the state laws because everybody in the group agrees of how any type of disputes are going to be resolved. John Wick is an example of that. If everybody's on board, there's what you mean. What that's why I'm saying, do you understand? Because if everybody is in agreement with it, if everybody is in agreement with it, then I don't understand the question. Everybody who's involved is in agreement with it. That's what it has. That's why you have to have an association or an organization. Let me give you this real quick. I'm gonna give you this. What's the thing doing, man? Okay, this is exactly where the limit of private ordering becomes important. Private ordering can replace public law, where the parties can voluntarily define their rights, duties, remedies, governance, procedure, and dispute resolution mechanisms by contract. Commercial agreements, trust associations, arbitration systems, corporate governance, and private standards are all examples. But the effectiveness of private ordering decreases as these things increase. Power asymmetry effects on non consenting Power power asymmetry effects on non-consenting third parties and control over essential access. I would measure when private governance becomes functionally regulatory by asking, is participation genuinely voluntary or is one party effectively unable to negotiate or walk away? What I was talking about earlier. Does the arrangement govern only consenting parties or impose consequences on outsiders? Does one private actor control access to an essential market, platform, resource, or institution? Are the rules negotiated or imposed through standardized adhesion contracts? Does the private organization investigate, adjudicate, punish, exude, uh, exclude, or otherwise exercise quasi-government powers? Is the government delegating authority to it, compelling its conduct or supplying coercive enforcement? There is also an important constitutional distinction. A private organization becoming, damn, I thought I put this on the screen. Hold on. It's not on the screen. Is that it? Yeah. Okay, private ordering is strongest where there is consent, privity of exit, and internalized consequences. Okay, there's also an important constitutional distinction. A private organization becoming powerful or regulatory does not automatically make it a government actor. The Supreme Court emphasized in Manhattan Community Access Corp. And Halleck that even extensive regulation, government licensing, contracting, or monopoly status ordinarily does not turn a private entity into a state actor unless it performs a function traditionally and exclusively reserved for the government. delegation of powers doctrine. But Shelley versus Kramer demonstrates the other side of the line. Parties may privately agree to something, yet when they invoke the coercive machinery of the state to enforce it, constitutional limitations can become relevant. The court distinguished the private covenant itself from its judicial enforcement. And that just goes back to what I was saying about, um, there was a case called Evans versus Newton that we read in our trust. I'm going to try to put this in layman's terms for you, where the senator, he had a private trust, and he gave some land to the city of Macon, and he had a condition that black people couldn't use it, okay, because they got freedom of association, and it was his private property, and he gave it to them in a trust, in a private trust. However, he gave it to public officials, and public officials are beholding to the Equal Protection Clause of the 14th Amendment, and they cannot discriminate. So there was a conflict of interest. All right. You took a private matter and put it into the public, and once you take a private matter and put it into the public, it now becomes beholding to the limitations of the Constitution. This is like when you mix public and private. When you mix public and private, now you're bringing in the regulatory authorities. So my thing to you, which that's a pretty good question as you posed it, is now that I'm reading it, I understand what you're asking, is that you got it's how it's set up. If you got a party of people and they all are agreeing on something, like the case of the ranchers up north in Montana, okay, they don't even know what the state laws are because they've all been conducting business with each other for so long under their reputational-based systems and the system that they got in place, that any type of dispute resolution and all that, they don't go to the courts. They know how to resolve it all themselves. They don't even go to the courts at all. So they don't even know what the state laws were, because everybody in that community has made up their own rules and how to resolve them, and everybody's in agreement with it, and nobody goes outside the group. If you have that, and then obviously you cannot drive a car it doesn't matter if you're in a group like that. If you're operating a motor vehicle that's on a public highway, you're going to be subjected to some sort of statutory regulation just by being on a public road. So there are certain situations you're not going to avoid that type of public regulation. So that all operates within the framework of, so when you say replace, that threw me off. I'm like, you don't replace it. It operates within the framework of the public. And that's what we were talking about yesterday. The public has carved this area out for you to operate in, and they have to leave. It's been reserved for you. Well, I don't know even if that's the right word, reserved for you, because it's your right to have that space, but that space has conditions. You exercise it within certain parameters. If private ordering relies on voluntary compliance, what happens when a party refuses to follow the privately created rules, and how does an enforcement differ from state coercion? Depends on what's in the contract. It's all contractual. That you make the rules up. Let me see what Chad says about that. You make the rules up. What happens? The question gets to one of the most important limits of private ordering. Private ordering is voluntary at the formation stage, but that does not necessarily mean compliance remains optional after legally enforceable obligations have been created. Once parties enter a valid contract, establish a trust relationship, agree to arbitration, create an association with enforceable rules, or otherwise assume recognized legal duties, refusal to perform can trigger remedies. Think of it in two layers. Private ordering creates the rule. Public law supplies the enforcement boundary. Suppose A and B voluntarily contract that A will deliver property and B will pay $100,000. The government didn't dictate those substantive terms. A and B privately ordered their relationship, but if B receives the property and refuses to pay, A doesn't ordinarily get to imprison B or seize B's property personally. A invokes an agreed private mechanism, such as arbitration, or ultimately invokes the state judicial machinery. That's where the state coercion enters. And that's what I was saying, behind any type, this is what I said, this is what we mean when we say all this operates within the public framework, because ultimately at the end of the day, if you're going to get some sort of enforcement, you're going to have to go to the public. And that's why it operates within a public framework. That's where state coercion enters. Private enforcement can include contractual remedies, termination rights, forfeit provisions where lawful, withholding future performance, expulsion from a private association, mediation, arbitration, liquidated damages, trust administration remedies, other consequences the parties validly establish. But those mechanisms remain bounded by applicable law. State enforcement is fundamentally different because the state possesses institutional coercive authority. A court can enter a judgment, legally authorized procedures, can garnish wages, levy property, compel discovery, enforce injunctions, or hold someone in contempt. In criminal and regulatory matters, government possesses still greater coercive powers that private parties do not possess. This creates an important paradox. Private ordering does not eliminate the state. It often depends upon the state to protect the privately created order when voluntarily performance ends. This is everything we were discussing yesterday. Kept talking about this yesterday. There's no such thing as you just being outside the private, outside any type of authority. That's why contract law is such a powerful example. Government doesn't ordinarily tell two sophisticated parties what price they must negotiate or every term they must choose. But government establishes the outer boundaries: fraud, duress, unconscionability, illegality, public policy, capacity, etc., and provides courts capable of enforcing legally valid instruments. Trust illustrates the same thing. The settlor can establish extensive private rules governing administration, distributions, trustee discretion, succession, and beneficiary interests. But if the trustee steals the corpus and refuses to account, the beneficiary's rights are not dependent merely upon the trustee's goodwill. The beneficiary can invoke judicial remedies to enforce the trustee's fiduciary obligations. So I would teach the principle this way. Private ordering means private parties create many of the rules governing their relationship. It does not mean private parties possess unlimited coercive power to enforce these rules. And that exposes a misconception about the phrase staying in the private, something that I don't like. And people always, I got to stay in the private. There is no impermeable wheel between public and private law. A relationship can be privately created and nevertheless become the subject of public judicial enforcement. In fact, that's one reason sophisticated private ordering works. The public legal system recognizes and within limits enforces the private order the parties created. The progression is consent, private rules, performance, breach, private remedy slash administrative private remedy, what is that? Administrative dispute resolution. Yeah. Administrative dispute resolution, judicial enforcement if necessary. What is very different from government regulation, where the underlying obligation may arise without your consent at all. You don't have to contractually agree to commit assault, evade taxes lawfully imposed upon you, or violate applicable highway regulations before the state can enforce those laws. That distinction, consensual source of obligation versus sovereign source of obligation, is probably the cleanest way to explain the boundary between private ordering and state coercion. I don't know if I would have been that verbose with it. I would just said, hey, look, the state, like what they were saying, we were saying yesterday, you can make a contract, but how are you going to enforce it if you don't go to court? What are the enforcement mechanisms ultimately that you're going to use? That would be my question. How are you enforcing it? I don't know what risk it creates. When you talking about private, to what he said, to what extent does mandatory arbitration to consumer or employment contracts represent a shift from public justice to private justice, and what risk does that create? I think we just explained that. I'm being redundant. Okay, you still going to be subject to public justice. Public justice is lurking in the background always. As a matter of fact, that's the coercive power of the private agreement. People knowing what could possibly happen if they have to resort to a public forum to have this dispute resolved. So it's not complete, but it's agreement. It's the power of contracts. I don't understand. You're asking, to me, you're asking a redundant question, but I'll put it in chat anyway. To what extent does mandatory arbitration in consumer and employment contracts represent a shift from public justice to private justice, and what risk does that create? That's a very good question because mandatory arbitration is one of the cleanest examples of private ordering displacing part of the public adjudicated process. At a basic level, the shift occurs when parties agree or are required as a condition of employment or service to resolve disputes in a private forum rather than in a court. The substantive law may still be public law, but the form at a basic level, the shift occurs when the parties agree or are required as a condition of employment or service to resolve disputes in a private forum rather than in a court. The substantive law may still be a public law, but the form, procedure, decision maker, discovery rules, confidentiality, and appellate review can all become privately structured. That can be efficient. Arbitration is often faster, less formal, and less expensive than litigation. Sophisticated commercial parties may prefer it for exactly those reasons. The concern becomes much more greater in consumer and employment contracts, where bargaining power is unequal. A worker or consumer may technically consent to arbitration, but realistically, the choice may be accept the clause or lose the job, account, service, or transaction. That is, and you're asking a question. I had to think about this for a second. You asking about a worker. I'm not, I had to think about that. I'm like, employment contracts. Listen, we're not dealing with employment. All right, we're dealing with privacy. That's why I was kind of wondering. I said, this dude is asking me about employment contracts. I mean, I don't deal with that. I don't deal with that. We're talking about privacy. What type of expectation of privacy do you have when you work for somebody and you have an employment? You may know something I don't. I know a whole bunch of stuff you don't. I know something. Everybody on here might know something I don't. What is that saying? That's not saying anything. I don't know everything, and you don't know everything. Everybody knows something somebody don't know. What type of what type of question is that? If you watch John Wick, you'll see they adjudicate everything privately among the organization or parties. That's why I say it's an excellent movie. But he's talking about employment contracts. And I'm like, employment contracts? You talking about ones you use social security numbers on? Nah. That's a different type of thing, right? Even though arbitration is part of private ordering, but that's not what we're talking about. You can't write contracts. You can't write contracts against public policy. You should already know that. And YouTube is a private ordering ecosphere. All you gotta do is look at their terms of service, see how they operate. I just did all of this. I'm doing. Matter of fact, I'm doing the terms of service for SPC University and making it operate private. I'm doing what you're talking about right now. That question that you just asked, I'm in the process of doing that right now. Right now. He getting all these questions off Chat GPT too. He ain't writing these questions. He getting these questions off his AI. I can tell because they're written too well. Very few people come into my chat they can write like that. Many men know many things. No man knows everything. I know it's like he tell me he knows something I don't know. Like everybody knows that. What you talking about? Everybody knows something that somebody don't know. That's not saying anything. Let's get back to the document real quick. Where I just put it? Okay, here it go. All right, so the recurring execution failures. All right. So as we were saying earlier, capacity is conferred, not claimed. You ain't claiming a capacity. You have to confer a capacity is conferred through some sort of document. There has to be some sort of traceable. There's some sort of source of the authority that is being conveyed. The recurring execution failure, signing as trustee when no trust holds title to the property in question, a trustee of nothing binds nothing, signing for an entity without checking whether the operating agreement, bylaws, or resolution actually confers authority on that person for that act. Many governing documents require member or board approval above a threshold. Relying on a power of attorney that was terminated, was never durable, or does not cover the transaction. Class, state law varies, and acting as an entity that was administratively dissolved and never reinstated. These are execution failures. Signing as a trustee with no trust holds title to the property in question, a trustee of nothing binds nothing. Signing for an entity without checking whether the operating agreement, bylaws, or resolution actually confers authority on that person for that act. Many governing documents require member or board approval above a threshold. Relying on a power of attorney that was terminated, was never durable, and does not cover the transaction. And acting for an entity that was administratively dissolved and never reinstated. Each of these produces the same outcome. The instrument is voidable or void as to the purported principal, and personal liability may attach to the signer. Verify authority before execution in writing every time. Same objective to instruments. The recurring pattern is that the objective is achievable and the chosen instrument is wrong. Some examples. I keep a business dispute out of court. Okay, this is what fails. Instruments that fail, an instrument that works. What fails, declaring the court to lack authority. That's what all y'all like to do. What works, an arbitration clause with a named administrator, seat, rules, and arbitrator selected method, drafted before the dispute. Avoid probate. What fails, asserting that probate does not apply. What works, a fully funded revocable trust with clear distributable standards and successor trustee provisions. Probate is avoided entirely by the ordinary operation of law. Limit exposure of personal assets. What fails, a declaration of exemption or a nominee arrangement. That's what everybody like to do. They like to declare, hey, they got my car impounded. I filed a UCC1 on it. Just ridiculous. What works, an entity properly capitalized, separately banked, formality observant, with adequate insurance. Plus, for future claims, appropriate trust planning with fraudulent transfer limits. Control who may participate in an activity. That's your objective. What fails, styling of public-facing operation as a private membership association. What works, genuine associational structure with real admission criteria, real internal governance, and no public solicitation, plus compliance with whatever regulation attaches to the underlying activity. Like, for instance, in the security, in the SEC, on the private placement memorandum, you can do everything privately, but they still will regulate compliance and things of that nature because you're using their facilities, even though the contractual agreement and contractual arrangements are private. You still have to, even though you're doing something privately, if you're going to go through them, you have to make sure that everything is drafted with the notion in the back that all roads lead to court. No matter what you do, there's always going to be the potential that you may have to go into a courtroom, and you always have to keep that in mind. The document being read, somebody said, what is the document being read? The document being read is a document that is on SPC University. When you go back and watch this video again, I show you what the document is at the very beginning. This is an example of a handout that my students get. If you're a member of SPC University, you will get documents like this and a lot more. I probably have 100 documents like this that explain different things. Today, I'm just electing to go into private ordering because people need to understand private ordering so people can do the correct process. A lot of people out there are attempting to create or conduct processes claiming to be private, and they're fundamentally off because they don't know the fundamentals. What are the fundamentals of private and public, and how do they relate to each other? They're two distinct domains. They are not labels that you put on each other. They are domains that when you conduct your affairs, you have to understand when you're in each one of them. If you're conducting your affairs privately, there are rules that are associated with that. And when you're conducting affairs in the public, there are rules associated with that. It's not a label you carry around saying I'm in the private or something like that. That's not how it works. They don't mix. Public and private doesn't mix. It doesn't mean that you have to, well, I'm completely in the private. People saying that right there, that's not the right way to be thinking. That's going to get you in trouble thinking like that I'm in the private mess. Stay away from all those colloquialisms. People making up their own words to describe things. That's not how law operates. You need to stay away from those colloquialisms. All right, so the complete principle. Okay, wait, I'm sorry. Reduce dealings with regulators. What fails? Structures whose purpose is opacity, which reliably increase scrutiny. What works? Choosing an activity, entity, form, and transaction whose structure, whose compliance profile is simple, and then maintaining it. Resist an unlawful government act. What fails? Notices, affidavits of status, or unilateral revocations. What works? A timely, specific, properly preserved objection, a motion to suppress or dismiss, like a subsection 1983 or statutory action, an administrative appeal taken within the deadline. You got to follow their rules when you come into the public. You're not making up your own rules. You come into the public. You can't make up your own documents and things like that. That's like coming onto the game board trying to make up your own rules to play the game. They're not going to permit that to happen. The completeness principle, where the leverage actually is. Court's involvement in a private relationship almost always begins the same way. The relationship encountered a question the parties never answered, so someone asked a public institution to answer it. And this is one of the biggest problems with trust. A lot of people think that all trusts are equal, or you can just get on ChatGPT and create you a trust, which you can, but that nothing is going to replace experience. You need to know what to put into ChatGPT so it'll know what to consider. There are all kinds of things that need to be taken into account when drafting a trust indenture agreement. That ChatGPT is just going to give you a basic trust indenture agreement. If you were to come to class, you would understand the difference between someone who actually understands how to put a trust together and then somebody just giving you a generic document. Right here it says, every question your instrument answers in advance is a question no court has to answer. Every question it leaves open is an invitation. It follows that the effectiveness of private ordering is a function of completeness and clarity, not of distance from government and not of assertiveness. The most effective private ordering is usually the most boring, thorough, specific, conventional in form, and drafted long before anyone is angry. The instrument that governs nothing. The most common real-world failure in trust planning is not drafting failure. It is a funding failure. A trust is a set of instructions attached to property. If no property was ever transferred to the trustee, the instructions attach to nothing, and the document governs nothing, however well drafted. Funding is a series of ordinary, unglamorous public and private acts, deeds executed and recorded, accounts retitled, entity interests assigned on the books, beneficiary designations updated, promissory notes endorsed. A pour-over wheel in is a backstop, not a substitute. Assets that reach the trust through it pass through probate first, which defeats the object. Structural. The same failure appears in every instrument family and an operating agreement from an entity never formed, a security agreement never perfected, and an arbitration clause in a contract never signed. This is also the completeness principle applied to execution rather than to drafting, and it connects directly to pattern 4. If title did not move, control and benefit did not move, and nothing changed but the paperwork, and that's right here is directed at all of you out here that think that you could just claim some sort of status. All you did was claim a status, file some paperwork, but nothing really fundamentally changed. You're still involved in the same activities, still running your life exactly the same way, but all of a sudden now you expect to get a different result. Stated as a drafting rule, foundations before remedies, the instrument written before the dispute determines whether a remedy has ever been sought, has to be sought. This is where the discipline pays, and it is not glamorous. All right, so here's our diagnostic procedure. Run these 8 questions in order before drafting any instrument or advancing any position. Stop at the first one you cannot answer with a citation. 6.1, the protocol. What activity is actually being conducted? Describe it in conduct terms. Notice we said conduct. What is done, for whom, and for what consideration without using any label from the instrument. Classification follows conduct. Classification follows conduct. Number 2, is that activity regulated and by whom? Federal, state, local statute, regulation, licensing board? If yes, the regulation is the floor. Identify the specific provision. Number 3, who are the parties and who is affected but not a party? Creditors, spouses, minors, employees, customers, taxing authorities, the public. Nothing in your instrument reaches anyone in the second group. Number 4, each term you want. Is the governing rule mandatory, default, or altering? If mandatory, stop. Redesign the objective. If default, proceed. If altering, comply with its form precisely. Number 5, what makes this instrument enforceable and in what forum? Name the statute or doctrine that gives it effect and the tribunal that would apply it. If you cannot name one, the instrument has no effect. Number 6, does the arrangement change actual control and actual benefit? If the same person decides everything and receives everything as before, the arrangement will be disregarded regardless of drafting quality. That's substance over form. Number 7, who is signing and in what capacity and what confers that capacity? Name the instrument, statute, or resolution that gives the person authority to execute this document for this principle. The answer is the signature block itself. There's no authority. And number 8, that's when you say the authorized representative, people sign it and things like that. Has it actually been done? Property transferred, filings made, register updated, accounts retitled. An instrument that was drafted but never executed on the ground governs nothing. Warning signs in any material you are given. Apply these to any instrument, seminar, form, or argument presented to you, including material from this institution. Citations without pin sites or citations to cases that do not exist. Pull every case. That is very bad within these circles. You have a lot of people out there circulating citations of authorities that don't exist, or what they claim was in the case is not really in the case. You got to read these cases. There's a lot of them floating around like that. People will make them up to try to push home their point. See, this is what the law says, but they just made up the citation because they know that you're not going to pull it and read it. Run everything through your AI and get some sort of confirmation. Quoted language that does not appear on the cited page. This is the most common defect in circulated material. Reliance on dicta, dissents, or concurrences presented as holdings. I've seen people do this, quote somebody, a judge's dissent, and act like it was like some sort of law or something, Reliance on decisions that have been overruled, suspended, or confined. Always check subsequent history. A good example is this is the Washita and the heirs of Henry Turner in 1848, where they're telling everybody they won their case. What they neglected to do is tell everybody the case was overturned in 1850. All right? Any claim that a particular form of words produces a legal result without regard to conduct. Conduct is always the underlying thing that's being examined, but in the echo chambers, they do not acknowledge that at all. They think that it is just words govern everything in labels. They don't have to change their conduct. They don't think they have to. They like children. Any claim that a body of law does not apply to persons who decline to accept it. All right, you talking about you need my consent. That's not how it works. That is not how it works. That's not how law works. That's not what they mean by consent. There's implied consent and there's express consent. You can give consent through your conduct, but people don't like to use the word implied because implied refers to conduct. So in the echo chambers, they never refer to that. They always think that consent has to be expressly written down on a piece of paper, but they won't ever address implied consent, which is consent through your conduct, things you engage in. An absence of any statement of what happens if the argument fails or who has tried it and what the reported result was. The last one is decisive. Every technique in this area has been tried. The reported cases exist. If the material presenting a technique does not tell you how it fared, that is because it fared badly, and that omission is the answer itself. Is itself the answer. All right, and then we have a verification exercise, and that's for the students. All right, so this document It was 21 pages long. The realities of private ordering, what it is, where it operates, and where it stops. This is an excellent document. This is a handout that is on SBC University. Once again, I'm having this, you may want to pick up this verification doctrine. This is another excellent document that I wrote. The verification, I think it's almost like 100 pages. Um, and it is an excellent, 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 excellent document. It's like one of our flagship documents. This for all you people who like to, like where does their delegation of authority derive from? This right here is going to help you out, help you get an understanding of that. Somebody said, why would you use something that can be overturned? Well, you tell me what can't be overturned. Yeah, laws can be overturned. That's why they have good law and bad. You know that the legal term is good law, and you have a legal term called bad law. You do know that, right? You talking about why would you use something that be overturned? They have some of the silliest questions. So you think that there's something out there that exists that can't be overturned? Is that what you're saying? That it's not subject to change. Tell me what that is. I'll be interested in you. I'm really interested in how you're going to answer that question. Tell me what you know that can't be changed. I'm kind of interested in that. He said, why would I use something that can be overturned? You don't have any choice. What do you mean? Why would you use something? Principles are what are applied in court. What are you talking about? Even in overturned cases, principles apply. Same principle is being applied. Y'all got to get rid of this sovereign citizen mentality that you think that you don't have to follow any laws. I used to didn't think that. Because like when I would see like the attorneys and stuff, they say sovereign citizens think that they don't have to follow any law. They telling the truth. You motherfuckers are crazy. You don't think you have to follow no fucking law. You think you can make your own law up. You crazy. You're going to jail. They're going to lock your ass up. I'm trying to tell you. They locking y'all asses up. And then I'm going to tell you something too. Notice how every guru that has gotten locked up, none of them, not a single one of them have come out of jail talking the same shit that y'all talking. Not one. Not one. They go to jail, they quiet as a church mouse. They ain't talking this shit that y'all talking right here anymore. That's why I say you're going to go to jail and you're going to get as long as you keep thinking like this, they're going to lock your ass up. That's where you headed, to jail. Yeah, it's where you headed, to jail. You tell me, why would I follow something like you don't want to read case law? Case law is what governs. Everybody who is intelligent, any good businessman understands the case law. The case law is what governs all the business. That's crazy. Okay, well, then you're using something that can be changed. If you're respecting all laws, then why are you asking me why would you want to use something that can be overturned? If you're respecting all laws, then you respect the laws of the United States, and the laws of the United States can be overturned. So what are you talking about? Y'all say some crazy stuff. Y'all say some crazy shit. Y'all do. Major Rosen's document can be found where? I don't know. I found that document a long time ago. I had it on SPC University for the longest. Y'all could have went over there and downloaded it. Let me see. The Army. Let me see if I can pull it up real quick. Because I found it on the internet. Where do you think I found it at? On the internet. Let me see where. The Army lawyer. The Army lawyer. The Army lawyer. Let me see. The Army lawyer. Department of the Army. Army lawyer. Military, the Army law. Yeah, I just pulled it up. Well, no, this is their one. Headquarters of the Army. Oh, they got some more. Oh, they got some additional. Let me see if I can find the old one. They got the Army lawyers. Oh, they got a whole bunch of editions. I see that. See, this is an old copy of the Army Lawyer, so they got like new copies of it. It's like a periodical. Let me see if I can the Army Lawyer. Let me see if I can. What year is this? 1988. Let me see if I can pull it. This is a 1988 Army Lawyer. Is this it right here? Let's see. Is this it? No, it's 2003. It's on my computer. You know what? I can give it to you. I'm gonna do it like this. Yeah, I'll give it to y'all. I forgot. I can just put a link to my Dropbox. Let me share it real quick. How do I share this? All right, let me try to share this. Okay, so if you look in the chat, I have given you the link so you can download if you're interested in this Army Lawyer. See if you can get it right there. There it is right there, the Constitution. There it is right there. So you can click on that, and I think you should be able to download it right there, the Army Lawyer. If you are interested in it, just download it but that's where I found that. I was just reading that article. In there. But if you're thinking that you can operate outside the bounds of the public, just get rid of that thought. That is not how private ordering operates. Y'all gonna have to throw away a. You know what the problem is that a lot of people they got that straw man, that person thing misunderstood, public versus private misunderstood. They try to use a label. They think that by declaring something fundamentally changes without putting a structure in place or something like that. Those are some of like the major problems that most of you are having following those people over there that are teaching you things. They don't know what a person is. They don't understand public versus private, and they think that by declaration something can fundamentally change about your status, and that now your status has changed, and now something has fundamentally changed in your relationship to the government. And those are the problems. The things that you're attempting to do, some of them can be achieved, but not in the methods that you're trying to achieve them in. Not like what you're trying to achieve, how you're trying to achieve them. Let's see. All right. So, with that being said, that's it for me today. I'll be back on later. I got a class tonight. We have a trust class tonight. I'm sorry I missed class the other night. I got caught up in something, man, and it slipped my mind, man. I had class on Tuesday. That doesn't normally happen, but I had guests in town. A lot of things were going on, and it kind of slipped my mind. So I will be in class. I'm admitting that publicly right now. I will be in class tonight at 9 p.m. So make sure you're there. Also, once again, there's a webinar this weekend. Okay, it's going to be incorporating a lot of these things that we're talking about because I'm fundamentally changing a lot of different things about a lot of the processes that I'm utilizing. Then that I got a better understanding of things. Okay. And of course, some of these things that I addressed earlier, what the person is, and uh, public and private, and it's declarations and everything people are trying to utilize. There's an actual structure that needs to be put in place, And that's what we're going to be looking at. Okay. Thanks. Take care. We appreciate it. I appreciate you. Some of the work that Jamie C. Lovett does is truthful. Uh, okay. Well, that's to you. Let me say, when you come on and you try to pump up somebody else, all you're doing is demonstrating that the blind follows the blind. You believe in something that somebody is saying. That just means you don't understand. Your level of intelligence is not. A fool will listen to a fool. When the blind lead the blind, what did Jesus say? Jesus said it real quick, because you might think you smart, and yet you don't know what you're talking about. That right to travel shit is some bullshit. What Jesus said, the blind leading the blind. Spoken by Jesus in Matthew chapter 9. What did he say? Let them alone, leave them alone. They be the blind. Oh, this is Matthew 15:14. Let them alone. They be blind leaders of the blind, and if the blind lead the blind, both shall fall into the ditch. Leave them alone. You want to believe somebody telling you the truth? Go ahead. Well, you do believe you. Well, you do. Somebody say, Yusuf, are you a U.S. citizen? When I'm engaged in U.S. citizen activities, see, there you go with the label again. Listen, I just got through talking about that. See, you are into labels. See, there's activity that you engage in that you're going to get designated a U.S. citizen. All right. A U.S. citizen, you got this label. You try to put labels on things, but you're not looking at the conduct. If I said I'm not a U.S. citizen, I'm still going to get treated like one if I engage in certain activity. It don't matter what I call myself. That's what I'm trying to tell you. Leave that sovereign citizenship. That's sovereign citizenship. That's sovereign citizenship. I'm trying to tell you, there is such a thing as sovereign citizen. Once you really start seeing what they believe in and how crazy it is, once you really understand how the law operates, you'll see that that's crazy. It's your conduct. I done said conduct about 50 times. This dude gonna say you a U.S. citizen. It don't matter if I say yes or no. What does that have to do with anything? You think if me calling myself not one is gonna fundamentally change something? They only have authority over U.S. citizens. No, they have authority over conduct that you engage in within a public regulated space. They have that authority. They have authority over you just by you being present. That's the truth. The shit that you are talking about is some echo chamber sovereign citizen bullshit. It just is. Y'all worried about whether you call it a U.S. citizen. That's you worried about labels. Yeah, but how are you gonna ask me that question? I just got through spending an hour talking about conduct and labels. That's what I just been talking about. The stuff that y'all talking about, this thing, you think that if you're gonna denounce being a US citizen and therefore certain laws don't apply to you anymore. Is this what you think? Isn't that the prevailing thoughts over there? That just by writing a letter, an affidavit, or a declaration, sending it to someone, saying you're not a U.S. citizen, even though you still engage in conduct that all the U.S. citizens engage in, but somehow now you're exempt from that conduct? It's just I'm just asking a question. I'm just asking a question. I'm just asking a question. Are you a U.S. citizen? Oh, I'm not triggered on anything. I'm not triggered or anything like that. Listen, I put the Army manual in there. This document is only available on SBC University. Hope to see you tonight. I'm out. Like, comment, and subscribe, and I'll see y'all on the next stream.